State and District Consumer Dispute Redressal. They have requested us that they would like to felicitate Honorable Mr. Justice M. Sundar and also Honorable Mr. Justice Bharat Chakravarti. So we will request the State of Andhra Pradesh to please come at the dais and first felicitate Mr. Justice M. Sundar and then please felicitate Mr. Justice Bharat Chakravarti. Quickly beginning with the session, before we begin with the session, a quick reminder, we'll request all the participants to kindly not utilize your mobile phones during the session. Please keep it on silent mode or switch it off. We'll also request them, the session is for 1 hour, kindly not to leave the room. And also we request kindly permit the resource person to complete the sentence before you could raise any queries. Thank you so much. Now I would like to invite Mr. B. Sundar to introduce our resource person for session 2 of day 3.
Good morning. First of all, I would like to thank Dr. Srinivasan, the professor and the principal of this law college, for setting up this huge capacity building program, and also the management of Hotel Sunway, because without them we would not be here. Good morning, my name is B. Sundar. I am the president of District Consumer Disputes Redressal Commission of Theni District in Tamil Nadu. and it is my proud privilege to welcome respected Lordships M. Sundar, respected Lordships G. Bharata Chakravarti, Professor M. Soundarpandian, the principal of Mr. Srinivasan of Dr. Ambedkar Government Law College, Pondicherry, and all our brothers and sister participants from the various commissions who have come here for this session. It is my proud privilege to introduce Lordship Justice M. Sundar. Lordship graduated from Madras Law College on 19/7/1966. He was born on 19/7/1966, and he completed the first 5-year course batch and enrolled in 1989 as a lawyer in Madras High Court. Thereafter, the Lordship was elevated, and before that, he was a counsel with Tamil Nadu Government TWAD Board from 2003 to 2006, and he was designated as a permanent judge of Madras High Court on 5/10/2016. I have the proud privilege of welcoming Justice M. Sundar, who is here to speak about the future of consumer law. Kindly rise on your feet and give a rousing Pondicherry welcome to our Justice.
Now I'll request Honorable Mr. Justice M. Sundar to kindly address the gathering. Thank you.
Honorable Justice Bharat Chakravarti, Dr. Professor Srinivasan, Mr. Abhinav Gupta, other staff and faculty, pardon me for not taking the names of each one of you, of the Dr. Ambedkar Government Law College, Puducherry, all the participants, judges who have travelled from various states to be here, to be part of this capacity building workshop, other activists who are here. I've told some non-governmental organizations and members are here, and most importantly, the Fourth Estate, press and media. Good afternoon. Greetings. New Year greetings too. This is the last session, I'm told. So therefore, effectively, this is the 50th over. So we will get into a bit of andragogy. The topic which has been given to me is Future Roadmap to Development of Consumer Law in India with Global Best Practices. I also saw one other topic on the impact of artificial intelligence. I thought we'll combine these two and try and have a lively discussion on this whole subject. As regards future roadmap, before I even plunge into the topic, broadly I would tell you what I intend telling you in a capsule. What I intend telling you is this consumerism or the statute is gravitating towards two areas in the future. One is the ADR regime, Alternate Dispute Resolution regime. Two is the digital technology, the digital era. These are the two areas which it is gravitating towards in future. That's the reason why I said I would touch upon artificial intelligence also a little. These are the two areas. And because it talks about global best practices, I just picked out a few aspects of the UK position, United Kingdom position. And I've culled out 5 principles which I would be putting before you as a slide for your consideration and thought. This is broadly what I'm going to do in the next 55 minutes at my disposal. We will start with what happened day before yesterday. Day before yesterday, one set of rules was published by the government calling for objections and suggestions. That is the Digital Personal Data Protection Rules 2025. I'm sure all of you read that in the papers. The parent act is Digital Personal Data Protection Act 2023, Act 22 of 2023. Interestingly, there is an intersectionality. Did anyone see that? Most of you are presiding over consumer courts, consumer fora. Did you notice the intersectionality? Did anybody see if the rules, the Digital Personal Data Protection Rules 2025, whether it mentions anything about consumerism, consumer action, or Consumer Protection Act? No, you've not seen it? I will tell you. Of course, it came in only day before yesterday. It was only on 3rd January 2025 that it was published calling for objections. Because subordinate legislation in its evolved form now calls for objections and consultative process as there in Corpus Juris Secundum you can see. That's a different issue altogether. If you see Rule 8 of the rules, that talks about the relationship between the consent manager and the data owner or the data principal. The data principal. That's all. It says the relationship between the consent manager and the data principal shall be fiduciary. That's all that it says. It also gives certain categories. If you see the categories which is there in 3rd schedule to the rules, the thrust is on e-commerce. And what they do is, they say e-commerce is as defined in the Consumer Protection Act and obviously 216, Section 2, subsection 16. I wish you had noticed this. This is the intersectionality. I just wanted to highlight the intersectionality. This is not the subject which we may really go into. I'll just read that for you. Rule 8 talks about consent manager and data principal, and that their relationship is fiduciary. And then the 3rd schedule gives the categories. If you go to the 3rd schedule, it interestingly says, give me a minute please, I'm just taking it out because I couldn't make a slide. It was only on 3rd I could make a slide on that. After giving the various categories, it says e-commerce entity means any person who owns, operates or manages a digital facility or platform for e-commerce as defined in Consumer Protection Act 2019, within parenthesis 35 of 2019, but does not include a seller offering, all that. We need not go into that. The point is there is an intersectionality. This is all that I wanted to highlight. Likewise, in the Parent Act also, I'm not going to read the provision. In the Parent Act also, if you go to section 19, subsection 3, there is a specific mention about the experience in implementation of consumer protection laws. Section 19 deals with chairperson and members and their qualifications. This is the scope of section 19. 19.3 specifically says the chairperson and members shall have experience in implementation of consumer protection laws and of course other social laws. It says. This is one major aspect which I wanted to tell you. The other intersectionality is with Mediation Act. There was a lot of discussion in the previous, very enlightening. I found whatever little capacity at my command stood enhanced. So therefore, I was honestly part of the capacity building exercise when all these questions were raised and the question as to who will pay the fee, and somebody mentioned about 12 capital A of the Consumer Courts Act, and somebody else mentioned about how the judge himself is functioning as the mediator, and payment of fee to the mediator appeared to be the issue. All this is fine. I wanted to, if you are clear, we will not spend time on that, but if that not be so, we'll just spend 2-3 minutes on that. This Data Protection Act, has it come into force or not? Because it's very important for all of you presiding over consumer courts. Has it come into force or not? Somebody tell us. Has it come into force or not? Data Protection Act, has it come into force or not? No. Has it come into force or not? Has it kicked in or not? No? For sure? How many sections are there in the Act? Roughly. It's all right. It's not a... None of the sections have come into force? How many sections have come into force? All right. This is of importance. This is of paramount importance. It proceeded on the basis of the previous session that the Data Protection Act had not come into force. Some of you were expressing that when Justice Bharat was telling you about the importance of mediation. Take it from me, whether it is Mediation Act or this Digital Consumer Protection, Digital Personal Data Protection Act, they are all conditional legislations. Please see subsection 2 or subsection 3 of section 1. It will make it clear that they are conditional legislations. Conditional legislations meaning the legislation is published with the assent of the President, but that does not mean that the provisions have kicked in. The provisions will kick in only on a notification on a given day, and in this case it is the government, central government, and it can notify different provisions on different dates. That is very, very important. You have to be very carefully watching the SOE notifications to be updated so that we don't make a mistake. For instance, in Arbitration and Conciliation Act, why I am insisting so much on this is, in Arbitration and Conciliation Act, there was an Amendment Act 33 of 2019, that's a conditional legislation. All the provisions have not come into force. Several judgments were rendered on the basis that all the provisions have come into force. I do not want to elaborate more on that. It was pointed out. Therefore, as officers, as judicial officers and members who are part of the consumer movement and the consumer adjudication entities, you should have absolute clarity on this and keep a tab on when the provisions are notified. Can we have slide 4, please? I just got it. This is the legislative history. This is the legislative history. Mediation Bill 2023 passed by Rajya Sabha on this day, passed by Lok Sabha on 7/8/2023. Mediation Act was notified. Actually, it was published rather than saying notified. Published on 15/9/23. Mediation Act is a conditional legislation consisting of 65 sections in 11 chapters and 10 schedules. 21 sections came into force. Vide SO 4384. SO is standing order. Standing order. SO 4384E on 9/10/2023, and those 21 sections are there. Now, how it becomes relevant is, you will see that all these 21 sections are now live. They've kicked in. The other sections are there as law, but they have not come into force. They have not been notified. What we are concerned with, what you would be concerned with, is section 65. The day section 65 is notified, chapter 5 goes. Chapter 5 of your Consumer Protection Act goes. Therefore, you have to be very, very guarded on this. Interestingly, the Consumer Protection Act 2019, is it a conditional legislation? That itself is a conditional legislation. That is the reason why I brought it up. Can we have slides 1 and 2 for a moment? I got the legislative history. When it was passed in the Lok Sabha, when in the Rajya Sabha, notified, came into force, 107 sections, 8 chapters on a particular date. And the next slide, please. Rudra and Bharti. Thank you, Rudra and Bharti, for helping me with this without the ticker. Thank you so much. Another SO 2421, and you have all these provisions coming into. The reason why I am highlighting is these conditional legislations. You never know. Section 65 might get notified one day, and without being aware of that, you may be referring something to mediation. 165 was notified, there is no chapter 5, and then section 27 comes into play, where the settlement arrived at itself becomes a decree. I was discussing with Justice Bharat in the morning, becomes a decree of court, which can be, as a civil court decree, which can be just executable. That's another matter. Before we plunge into this UK and the comparison slides, 2 other aspects which came up that is of immense importance. One learned member was saying that because of the issue regarding payment of fee to the mediator, and the litigants and the lawyers say up to 5 lakhs, there's no court fee, why are you asking us to pay? That's a very valid issue. We have to go into that. You said the judge itself was acting as a mediator. Somebody said that, you said that. Correct? I have some reservation on that. I have some serious reservation on that. The reason is this. In a legal process, legal adjudication, what happens in mediation cannot be looked into. Suppose you mediate. It succeeds, excellent. Wonderful effort, hats off to you. Suppose it doesn't, you'll hear the matter. You can't hear the matter. If it succeeds, wonderful. Take my hats off. Suppose it doesn't, you can't hear the matter. Because what transpired in mediation cannot be taken into account for adjudication. That's very important. Therefore, a good effort, a good Samaritan, but then please bear this in mind, because tomorrow somebody might say, in mediation I made all these disclosures to you, trusting you, and today you are using it against me in a judicial order. So there you might have some difficulty. And another gentleman here raised 12 capital A. 12 capital A of Consumer Courts Act, Commercial Courts Act 2015. 12 capital A, I don't know how far that may be a working mechanism for Consumer Protection Act. The reason is 12 capital A says that in a suit where no urgent interim order is contemplated, then this mediation becomes, pre-suit mediation becomes mandatory. Will such situations arise in consumer courts? So therefore, whether an equivalent of 12A can be adopted. Sorry? May not be adopted in its form, but can be made mandatory. Correct? Can be made mandatory. There may be no difficulty in making it mandatory. So that's a good suggestion. So it may not be 12A in its form, but then 12A in its principle. 12A not in its form, in its principle, whereby you make it mandatory, you make a pre-institution mediation. Please, here we will call it pre-institution. Pre-institution mediation, mandatory. That's a very good thought. That's a good takeaway. We can think about it because we are, yes. Please sit. Please, kindly be seated. Kindly be seated. And if you have a hand mic, kindly. You're audible. You're audible. Don't difficulty. Yes, please. No, but 89 doesn't talk about pre-institution mediation. Correct. But 12A is pre-institution. It says it makes it a condition precedent even for institution. 12 capital A of Commercial Codes Act 2015, which the other learned member was referring to, makes it mandatory for institution itself. That's very, very important.
Thank you.
So, this much about it. And then there was also one other topic which touches upon artificial intelligence and impact. While on digital technology and that era, I thought the topic actually says digital consumer protection in the context of artificial intelligence and emerging technologies. We'll spend some time on this. It's worth spending. The last session, so we'll make it as much of an andragogy as possible. Now, artificial intelligence, I will put it this way. How many of you don't use the AI app? How many of you do not use the AI app? You don't use. You also don't use. All right. So, a vast majority, you are an exception. So, you're an exception. So, you're in a huge minority. So, the vast majority is using AI app, one AI app or the other. Now, the next question is not in the negative, it's in the positive affirmation. How many of you use it to write your orders? How many of you have used it? Why should you not? You have used it. Very good. AI. Has anyone used AI for writing an order? The reason why I brought this up is we as courts, be it a consumer court or a regular court, are also service providers, and the litigants are consumers. Therefore, this impact of AI is something which we may have to really look at. What may happen tomorrow is, if a matter comes up before you saying AI was used, that produced this result, and that has led me into a loss, what are you going to do? How are you going to deal with it? Yes.
That generally is submitting to all, so that AI are not coming to Vijayawada district court or any other.
No, futuristic. You're saying futuristic. If it comes to you, because the topic is future.
So, if the government is applied, Your Honor, AP member and AVJ is supporting the idea.
The basic norm as regards the AI, I am just telling you the international norm, I will tell you. The basic international norm with regard to AI is consider, don't rely. consider, don't rely. That's very, very important. A lead case is Loomis in US. Some of you are nodding your head. You have read it, ma'am? So you are familiar with Loomis. Can you briefly tell us what Loomis is? Loomis case is about. We can make it interactive rather than. Please. Oh yes. Please. So therefore, Loomis is Supreme Court of Wisconsin, not Supreme Court of US, Supreme Court of Wisconsin. So please come up with that probably 5 minutes later, and then we will just have a quick discussion on that, because it is a very, very good judgment on how AI can only be considered but not relied. That was a case where AI was used in sentencing, in sentencing. A recidivism tool was used, Compass was used. So let ma'am give the details. Now coming back to this points as regards the UK scenario, because the topic talks about global best practices. What I have done is, I've taken out 3 recent case laws in UK, that would be towards the end, and I have culled out 5 points as I mentioned when I opened. One is on consumer rights. How is it in UK? How is it in India? 2 is dispute resolution. Again, a comparison. I've given a conclusion also. 3 is e-commerce protection. That is why I started with the digital era. 4 is penalties and enforcement. And 5 is sector-specific protections. I'll take you through one after the other. I'm not going to read the entire slide and bore you. Give you a broad overview. And the 3 case laws are lifestyle, Hastings, hip replacement, this endoprosthesis, and MasterCard. These are the 3 case laws which makes them very interesting reading. Now let's have slide 5, please. Consumer rights. I've made a detailed comparison. In India, it is right to safety, right to information, right to choice, right to be heard. There is nothing to. Something is being. Nothing to do with my slide. No, the slide is causing the noise.
No, sir, no, sir.
Thank you so much. So then, right to choice, right to be heard, right to
and the ruling was supposed to be inner working style. So it violates due process rights of gender, and race into account was taken, and the opportunity to rule on a sentence based on something artificial could not be taken. Is the gist of the case. I dare to speak before.
And what did the Supreme Court decide ultimately?
The result was they denied to take this certiorari as such.
Okay.
Thank you.
Long and short of it is, a person who's charged on 5 counts, rash driving of a vehicle and shooting. 2 simple counts he pleaded guilty, 3 other counts shooting, and other counts he disputed, went to trial. He was found guilty. When it came to sentencing, they used a tool called Compass, COMPAS. It's an abbreviation. It says Correctional Offender Management Profiling Alternate System. Correctional Offender Management Profiling Alternate System, COMPASS. Many of them call it an acronym. It's not an acronym because if it's an acronym, it has to have double S. It should be a dictionary word. Single S is not a dictionary word. It's an abbreviation. The report you Googled, right? The Google itself would say it's an acronym. It's wrong. It's not an acronym. It's that's the difference between artificial intelligence and natural intelligence. It's abbreviation. Ultimately, subject to correction, the name of the judge in the Supreme Court of Wisconsin was Anne. Anne, along with two of the other judges, came to the conclusion that the point was this. When it came to sentencing, this COMPASS tool was used to decide what sentence should be awarded to Lewis. He challenged it. That's all. The challenge was like this. He said, facts are there, conclusion is here. Where is the dispositive reasoning? Where is the reason? Where is the connection? He said, you use COMPASS. Nobody knows the algorithm, including the court, because it's a proprietary software. COMPASS is a proprietary software. The court also doesn't know the algorithm. So he says, due process of law has been violated. Ultimately, what the Supreme Court said was, COMPASS was not the sole determinant. It was only one of the determinants. Therefore, it is acceptable. But the caveat was, consider but do not rely. Consider but do not rely. Now that we have come to this, and we are on this, there is also a specific topic on this artificial intelligence. I wanted to ask you all, we have another 15 minutes, 10 minutes to 10. No, we'll wind up in another 10 minutes. 15 minutes, 1 o'clock, sharply. What is artificial intelligence? What is artificial intelligence? Can anyone tell us what is artificial intelligence? Sorry, use of? Because the topic which the organizers have chosen is actually dovetailing two topics. Digital consumer protection in the context of artificial intelligence and emerging technologies. That's why I thought we should discuss about this. It's very simple. Yes, please. Yes, please. To think like human, right? To mimic the human mind, correct? A machine mimics the human mind in very, very simple terms. That is artificial intelligence. In very simple terms, a machine mimics the human mind. If that is the case, does it have cognition? Does AI, you have so many AI tools. You have the ChatGPT, which is very popular, which most of you may be using. Then you have the Copilot. You have all these, it's another software application, that's all. But does it have cognitive skill? At all? Correct. Does it, if it mimics the human mind, does it have cognition or not? There is a division of judicial view. There is a dissent. It can be because Nick Bostrom, a Swedish philosopher who headed this Future of Humanities Institute in Oxford, they did a study on the existential crisis of human species. After this entire study, he came out with a famous or rather infamous, because he was called a doomsayer statement. He said, AI will be the last invention human beings make. This is Nick Bostrom for you, who's a Swedish philosopher who headed the Institute of Human Studies in Oxford. Anyway, that's beside the point. Now, you need to know tomorrow when you use AI in your day-to-day work, or when a matter touching upon AI comes up before you for adjudication in a consumer court, you need to have absolute clarity on what is AI. I will just try to simplify it. Rather, Bharat is technologically very sound. He will bear me out when I conclude. What I did was, I asked the AI tool whether AI has cognitive skill. That was the question. I'll try to read the question for you. The question is what I prompt. The prompt, it's not the question. The prompt was this: write a note on whether computers have cognitive skills. This is what I keyed in. I'm not taking the name of the app for obvious reasons. These are all proprietary software. Therefore, I don't want to be seen criticizing or endorsing, either criticizing or endorsing any proprietary software as a judge. I don't want to do that. Therefore, I'm not taking the name. My prompt was this: write a note on whether computers have cognitive skills. This was my prompt. It gave a long answer. I'm not going to bore you with all that. I'll read the conclusion alone. It says, while computers can perform tasks that mimic certain cognitive skills through advanced algorithms and machine learning, they do not possess genuine cognitive abilities like humans. This is what the AI says. Their intelligence within quotes, is limited to data processing and pattern recognition, devoid of consciousness, subjective experiences, or true understanding. Thus, computers simulate aspects of cognition rather than actually having cognitive skill in the human sense. This is the answer. This is the correct position too. That's why I don't want to be seen endorsing any particular, if these are all proprietary softwares, I do not want to be seen endorsing. This is the correct position also. The fundamental difference is this, please have this in mind, matters may come up before you. This is not completely futuristic, it may be very contemporary also. Matters touching upon use of AI may come up before you in the consumer courts. Very simple. There is a large data mine and you have algorithms. Algorithms are nothing but pre-programmed instructions. Pre-programmed instructions which are trained to search, look for patterns. So what happens is, when I ask this prompt, whether computers have, whether my prompt was this, I read it to you. Write a note on whether computers have cognitive skills. When I did that prompt, the algorithms found the data mine and look for patterns. It doesn't apply its mind. There should have been a pattern earlier. Then it picks out the closest pattern and gives it to you. It is more like a precedent search. Therefore, it can only mimic, though you say it mimics the human mind, it does not have cognitive skills because it looks only for patterns. This is very, very important as regards artificial intelligence. I would, Professor has just walked in. I should congratulate whoever was responsible for this topic. Whoever thought of this topic, I don't know who thought of this topic. It was a very, very thought-provoking topic with which is of immense relevance. I must congratulate whoever the team is responsible for this, including this topic also. Very well thought out, very well thought out. So this is this much about it. And lastly, we'll have a quick look at the 3 case laws and conclude. Can we go to the last slide, after this one? Rudra and Bharati. Lifestyle Equity CB and another versus Amazon. I've given the quorum of judges. I've given the facts and brief overview. The case of Lifestyle was centers on the alleged infringement of UK and EU trademarks owned by Lifestyle Equities, especially such and such. Lifestyle Equities contended that Amazon, through its US website, marketed and sold goods bearing this brand constitute and consumers in UK and EU without authorization, thereby infringing their trademark rights. This much about it. I'll just put out the slide in my device also. So ultimately, what the court did in this, because of global good practices, I have taken out this. You will find that Lifestyle Equity, we have 14 months, slide 14, Rudra. Slide 14. And there, what the case trajectory I have put in. I'll tell you what the Court of Appeal did. Lifestyle Equities appealed the High Court's decision. The Court of Appeal overturned the initial judgment, finding that Amazon's advertisements on Amazon.com did target UK EU consumers, thereby infringing on Lifestyle Equities trademarks. Amazon further, the Supreme Court said, UK Supreme Court. Amazon further appealed to the Supreme Court. On 6 March 2024, the Supreme Court upheld the Court of Appeal's decision, agreeing that Amazon's actions constituted trademark infringement within the UK and EU. This progression through the courts highlights the complexities involved in determining trademark infringement in the context of cross-border online sales and the importance of considering how online marketplaces may target consumers in different jurisdictions. Some overlap matters may come before, because e-commerce is really on the rise. So therefore, I thought I'll highlight this. The other one is, we'll have slide 15, please. Hastings. This is a case where somebody underwent a hip replacement using prosthetic hip. After experiencing complications, he claimed damages. This is a very nice read. This makes a very good read on known complications, which most of you would have dealt with in medical negligence cases. This makes a very good read, and it strikes a very good balance. And this is reported in 2022 UKSC 19. I'll just give the conclusion this way. This decision underscores the importance of evaluating product defects based on the expectations of safety that the public is entitled to, rather than absolute guarantee of safety. It highlights the need for consumers to be aware of the high risks. This, most of you would have seen known complications in medical negligence, but this makes very good reading. And the next slide, slide 16, gives the trajectory. This highlights complexities involved in product liability cases, particularly concerning medical devices, and underscores the rigorous standards required to establish a product as defective under the Consumer Protection Act, particularly medical products and processes was the case here. And the last one is MasterCard. In MasterCard, I've given the facts. This was a class action. This was a class action where the question arose as to whether you should be able to demonstrate entitlement, collective entitlement at the initial stage. The court said no, it is not necessary. This makes again a very, very interesting read. And I have concluded like this. I'll just read the conclusion and we will conclude the session. This progression through the courts, this is slide 18, Rudra and Bharati. This progression through the courts has been pivotal in shaping UK's collective action regime, particularly concerning competition law infringements and consumer protection. So we will conclude with that with regard to global best practices and how we make it robust. And before I show the last slide to you, slide number, don't show it now. The last slide is, before I show the last slide to you, I wanted to tell you on this ADR, Jeffrey Voss, who heads the UK civil law system, UK and Wales, England and Wales, he was talking in the Manchester University on this ADR. He said something very interesting. He said, ADR, alternate dispute resolution, is a linguistic problem for me. He said, don't call it ADR. He had an answer. After citing several instances and as to how it has to become an integral part of adjudication and dispute resolution, he said, instead of ADR, this is Jeffrey Voss. Jeffrey Voss, very recently Manchester, I don't remember the name, the Manchester lecture on, he came up with this. He said, call it IDR. This was lecture on mediation. He said, call it integrated dispute resolution. Don't call it alternate. Call it integrated dispute resolution. So that may really make a conceptual shift, which when the policymakers consider, there may be a conceptual shift in India today akin to global best practices, and that may make a world of difference. We don't know how much time it may take, but this is a thought which I thought I should share with all of you. Being the last session, I tried to make it interactive and share these thoughts so that we mull over it when we go back. And now we will have the most important last slide, slide 19, Rudra and Bharati. Thank you. Thank you.
As sir started, so this was supposed to be the 50th over. Possibly the participants thought of hitting 6 sixes of the 6 balls, but I tell you, on the first ball itself, sir, you bowled us. I should also tell you that discussion regarding artificial intelligence is not new. Way back in 1950, it was Alan Turing who raised the question, can machines think? And today as well, we don't have that answer. So we are enlightened to listen to your thought, and I tell you, I was talking about Jugalbandi yesterday. I think regarding ADR, or I should say IDR now, Integrated Dispute Redressal Mechanisms. So the Jugalbandi which happened between Justice Bharat Chakravarti and Justice M. Sundar was so beautiful, so enlightening, and so learning. So we thank you a lot, sir. Now I would like to invite Mr. U. Kashi Pandey for giving a vote of thanks.
Good afternoon to everybody. At the outset, I thank the principal and the organizers of the meeting for providing me this opportunity to thank their compassionate personality who enlightened us in the area of artificial intelligence and digital world, how to handle the cases in future. And I thank one and all.
I believe sir didn't want it to be between us and the lunch. So we thank him a lot for having a short vote of thanks. But on behalf of the participants, on behalf of Government of Puducherry and Dr. Ambedkar Government Law College, sir, we very humbly thank you for such an enlightening session, for making it interactive and raising very relevant and important issues for our judge participants. Thank you so very much, sir. I would request all the participants to please join us for lunch on the ground floor.